Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about judges behaving badly. Cases that should have gone to the Supreme Court of Canada, but didn't. Michel Girard was a judge who was repeatedly disciplined by the Canadian Judicial Council, and as a result of his involvement with the Canadian Judicial Council, it was ultimately recommended that he be removed from his role as a judge. The constitutional principle of judicial independence means that judges can't just be fired for doing their jobs, that there has to be something very significant that warrants their removal from office. And this is where that case got very interesting. The question became whether or not the Canadian Judicial Council was the person who had the authority to remove a judge from office, or whether there was a more significant process that had to be followed. Mr. Girard, for his part, filed a number of judicial reviews of decisions disciplining him and seeking his removal as a judge in order to protect his employment. The Supreme Court of Canada refused to consider the issue of how these cases should be resolved. And this is particularly interesting because the Supreme Court of Canada is made up by a number of judges, and the Chief Justice of the Supreme Court of Canada is the head of the Canadian Judicial Council. So these issues strike at the core of what judges have to do and what judges have to decide about one another, which makes these issues all the more important to our judicial system. If judges are constantly now being called for removal on the basis of deciding certain cases in certain ways, wouldn't it be better for the Canadian public to have a very clear decision from the Supreme Court of Canada about exactly what has to happen before a judge can be removed from office, and who has the power to remove judges from office, and on the basis of what conduct judges will be removed from office? That seems to me to be something that is so important in this day and age, where if judges render a decision in a judicial proceeding that the public doesn't agree with, there are protests and arguments and op-eds calling for removals of those judges. The public needs to know this is an issue of national importance that the Supreme Court of Canada is supposed to deal with. The public needs to know what the process is, why it's there, and if judges themselves can't figure out the process and are in dispute about what the appropriate process is, doesn't that raise concerns that the appropriate process may never be identified or followed, and that the public may never have confidence that the appropriate process is being used in appropriate cases? This is the exact type of case the Supreme Court of Canada is supposed to hear, and unfortunately they didn't. This leaves the issue to another day and another instance of perhaps a judge behaving badly in a way that calls for their removal from office. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in for another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has been instrumental in putting these videos together. Please like, subscribe, and share with your friends.